This is a lecture for my professional responsibility class. We're going to be talking about conflicts of interest and specifically about clients giving informed consent to a conflict of interest. And so you may remember, just a moment here, so we're talking about informed consent. We're focused on comments 18 and 19 to Model Rule 1.7. And you may remember that 1.7b allows attorneys to proceed with representing clients even when there is a conflict, as long as 4 conditions are met. And the lawyer reasonably thinks that he or she can provide diligent and competent representation in spite of the conflict. In other words, be unbiased. There's not some other law prohibiting the representation in this case, like some states don't allow joint representation in death penalty cases for death penalty defendants. You're not trying to be the plaintiff's lawyer and the defense lawyer in the same court case or trial. And then 4, each client affected by this conflict gives informed consent confirmed in writing. And so here we're going to be talking for a few minutes about what do we mean by informed consent. Informed consent requires that each effective client be aware of the relevant circumstances and of the material and reasonably foreseeable ways that the conflict could have adverse effects on the interests of the client. What are we concerned about here? I want to explain this for my students. When lawyers agree to represent clients, it's very common in one of those either first or second or third consultation, at some point they hand the client a bunch of forms, a bunch of paperwork to sign that are things like authorizations and powers of attorney, authorization to get medical records, whatever it is, an agreement about the fees and so forth. So the client gets a stack of papers and someone says, sign this, and they start going through and just signing their name on them. What we don't want is lawyers just trying to stick a waiver of conflicts of interest in that stack and have the client sign it and not really realize what they're signing and how serious this is. In other words, you have an ethical duty to explain to the client the nature of the conflict and what the potential consequences could be. You're going to have to take some time to make them understand, maybe. Otherwise, their consent will not be valid and you could be subject to discipline. So the conflict, consent to a conflict of interest has to be done with a client who is actually informed about what this conflict entails, and that's what they're agreeing to. Now, the information required depends on the nature of the conflict and the nature of the risks involved. And so with, is this a pretty serious conflict, and is it very likely? So for example, I mentioned in an earlier lecture, co-defendants in criminal cases, very, very common that the prosecution will offer one or more of them a plea bargain, a generous plea bargain to testify against someone else. And if that's the nature of the conflict, that's a pretty high risk, and then you need to explain that. If this is a really low risk scenario where you have someone who's selling his used car to his friend or something, I don't know why you would get a lawyer for that, but if it's low stakes or the conflict is very attenuated, then you don't have to do you still have to explain it, but we don't have to explain as much. Now, the comment 18 singles out a particular type of representation that they're worried about. And this is the type of conflict, not Greenacre versus Redacre, and you are doing unrelated legal work for one of them and representing someone else who's adverse for them. We're not talking, that still requires consent, but they're particularly concerned about the situation where you are representing co-plaintiffs or co-defendants. And so this could be co-plaintiffs in a lawsuit or co-defendants in a tort case. This could be co-defendants in a criminal case. It could also be a group of 2 or 3, 4 people who come to you together and want you to do legal work for them as a group. So it could be a couple, a married couple that wants you to do their wills, where they're just going to leave everything to each other and they want to use the same lawyer. It could be a few people who want to, 2 people who want to form a business partnership or a joint venture between two companies. And it could also be some people that a previous illustration was John, Paul, George, and Ringo come to you. They're a music band, let's say, and they want to start their own record label. And in those situations, it's harder for people to, non-lawyers, to see the conflict of interest. It's one thing if somebody's suing the other, but if they perceive that they're all on the same side in this legal matter, it's hard for them to understand why it wouldn't be a good idea to all use the same lawyer. And you have a duty to explain that. So you have to explain effects on loyalty, confidentiality, and the attorney-client privilege, and the advantages and risks involved. Well, the advantage is going to be saving money, right? One lawyer, in theory, is cheaper than 4 or 3 or however many you're trying to represent together. Loyalty, I want you to think about what happens when you get down the road in the well into the representation and they reach a disagreement or an impasse about whether to settle or accept a settlement or go to trial, or how to apportion the damages among them or apportion the income among them. There's some sort of dispute, and who's going to have the last word? Or as the lawyer, you don't get to play favorites. And they need to understand that this then can kind of blow up where each one is trying to get the lawyer to side with them, and you may have to withdraw. Confidentiality. Remember an illustration of the husband and wife who go and they want the lawyer to do a simple will for them where they each leave everything to the other. A couple days later, the husband calls the lawyer and says, by the way, I've never told my wife this. Please don't tell her, but you should know. I fathered a child out of wedlock 20 years ago and have never met the kid, but it might be relevant, and please don't tell my wife. This has actually happened, and now you have a problem. You're not supposed to keep secrets from the co-client in the same representation. And then it mentions attorney-client privilege. And we're going to go off slide for just a moment. We're going to spend kind of do a whole unit when we do the duty of confidentiality about attorney-client privilege and the rules. They're very important. They're tested on the MPRE, and attorney-client privilege is tested as an evidence rule on the multi-state bar exam. And so there's obvious overlap between the duty of confidentiality, which is an ethical duty for which you could get in trouble. If you violate it, you could get in trouble with the bar, and attorney-client privilege. They both relate to keeping secrets. There are some differences. And for right now, just keep in mind, attorney-client privilege, for purposes of this lecture, is a rule about what is admissible at trial. It's a rule about what is admissible at trial. It's not a rule about whether the lawyer is allowed to break a confidence or could get in trouble with the bar or something like that. That's not privilege, that's confidentiality. Privilege is when you can keep something out at trial as inadmissible. Also, keep in mind that in practice, the vast majority of lawsuits settle before trial, probably 95% or 96, 97, depending on the jurisdiction and the type of case. And what this means is that attorney-client privilege, when you're a practicing lawyer, functions as a discovery rule. And so the other side is seeking information during discovery, and you object to having to produce that information because it's protected by attorney-client privilege. So I don't know if they explain this in your evidence class, but in practice, in your life as a lawyer, attorney-client privilege is going to function as a bar to discovery. That's its primary operation in our legal system, that it during the pretrial discovery phase, you can refuse to produce certain information or make certain disclosures because on the grounds that it's privileged. Now, what this rule is alluding to is a sort of obscure exception, but it actually happens a lot, where if the people you're representing turn on each other and start suing each other later on, and it could be during your representation or years later, the conversations that you had as a lawyer with them will not be privileged. If they're sued by someone outside, we're still under kind of the cone of silence of privilege. And so I gave an illustration earlier. John, Paul, George, and Ringo come to you and they want you to help them start a record label. And that's all well and good. And let's say years later, they're in litigation with a computer company, Apple, that's using the same name for their company. Well, the conversations that those musicians had, those clients with their lawyer way back at the beginning, are not going to be discoverable and won't be admissible by this outside party. But if at some point Ringo decides to sue Paul over a dispute over, let's say, royalties from their songs or ownership share of or assignability of rights under the record label, um, the conversations that either they had together or individually with the lawyer back who represented them way back when will be admissible. So attorney-client privilege doesn't attach or apply to that dispute with co-plaintiffs and co-defendants who are sharing a lawyer. Now, your client may just roll their eyes and say, wow, if I wanted to go to law school, I would have gone to law school. Why are you making me listen to all this? It's hard to understand, but that is part, making sure they understand is part of getting informed consent. Under some circumstances, it may be impossible to make the disclosure necessary to obtain consent. This is very important. For example, when the lawyer represents different clients in related matters, and one of the clients refuses to consent to the disclosure necessary to permit the other client to make an informed decision, the lawyer cannot properly ask the latter to consent. So here we're talking about what in a previous lecture I called type 1 conflict. So you've been doing legal work for Greenacre, and someday Goldenacre walks into your office and says, I want to sue Greenacre. Well, you're not going to represent Greenacre in this matter, but the fact that you are currently drafting Greenacre's will or helping him set up a business or something means that he's your client for other purposes. And so you would have to get consent from Greenacre and Goldenacre. But let's say Greenacre says, by the way, you're not allowed to tell other people that you're representing me. And I don't want anybody to know that I hired a lawyer. Or Goldenacre tells you that. And this does happen where there's people. So I'm going to give you two quick scenarios. You could have someone who, a spouse who's contemplating getting a divorce. They go and they talk to an attorney about it, and they had been under the impression that they were sure to get full custody of the children and all of the assets of the marriage and keep the home, and the lawyer kind of gives them some bad news that given their situation, that's not going to happen. Well, they may decide not to go through with their divorce, and they don't want their spouse to know that they consulted with an attorney. The same is often true when you have an employee who feels like they have been wronged at their workplace by their employer, that somehow their rights have been violated. They go consult with an attorney about maybe litigating against their employer. The attorney says, you're never going to win that case, and you have a loser case, and they don't want their employer to know that they talked to a lawyer. And so in that case, or the attorney says, oops, I think I have a conflict, you have to get permission from each side to disclose to the other, or you just have to say, I can't represent you, or I have to withdraw because of a conflict of interest. Please keep that in mind. This is a easy one to turn into a tricky test question. In some cases, the alternative to common representation can be that the party may have to obtain separate representation, and with the possibility of incurring additional costs. And these costs, along with the benefits of securing separate representation, are factors that may be considered by the affected client in determining whether common representation is in the client's interests. In other words, the upside of sharing a lawyer for people is that it's cheaper. And sending them either a group, making John, Paul, George, and Ringo all get their own lawyers, of course, is going to be more expensive. But even in a situation where you've been representing Greenacre and Goldenacre comes and wants to sue Greenacre, it may be that you're the cheapest lawyer in town. And if you send one of them away and say you have to get another lawyer, every other lawyer is going to charge them a lot more. It's possible. And so you have to discuss this with the client, right? I know it will be cheaper if you consent to this, but then you should be aware that there's downsides. Um, just as an example case, this is from 2008 in the Sixth Circuit. You don't have to remember this case name. I'm just pointing it out. A client had vague and general knowledge of a firm's prior legal work. That's not an adequate foundation for informed consent. There's one kind of last point I want to make about informed consent with, and it's going to come up with this and some other legal matters, some other ethical rules. It partly depends on the client. And so we have a spectrum of sort of levels of sophistication or knowledge about the law. If you are dealing with a very sophisticated repeat user of legal services, and I'll give it the extreme example, is in-house counsel at a corporation has approached you about outsourcing some of their litigation to your firm, Well, you can say, okay, so I have some potential conflicts of interest, and you disclose it. And general counsel, in-house counsel at the corporation, they're a lawyer too. So they're going to track with you very quickly, be aware of the implications, think it all through, and probably say, fine. That's actually one of the most likely scenarios where they will give consent to a conflict because they're a lawyer and they know what the implications are and they can easily evaluate the risks. And they may decide that it's lawyers are more likely to be aware this case is going to settle before trial, and so this conflict doesn't really matter. On the other hand, you could have a layperson, a non-lawyer, who's never hired a lawyer before, and very common, and they don't really understand what you mean by conflicts of interest or attorney-client privilege or things like that. And for an unsophisticated, maybe first-time user of legal services, your ethical duty will be to do a lot more explaining, and explaining in terms that they can understand. What's the definition of whether you're covered in terms of a disciplinary action? Whether they understood, right? It's informed consent. It's not how much you explained, it's how much they understood. So you need to explain however much it takes for your client to understand the significance of what they're consenting to when you ask them to consent to a conflict of interest.